I want to come back to the exploitation, because that's the more important part of this case. And it again, just to remind you, the English text is not relevant, but it says the direct use. The Spanish text says de la utilización directa, the direct use. And then the Dutch text has this uit de rechtstreekse, the direct, exploitatie, which is a strange word because the Dutch could have also used the word gebruik, which would have meant use. That's literally the meaning of the word gebruik. But in any case, the Dutch text talks about exploitation, right? And the Supreme Court says this is not affected by the fact that the term exploitation as such is not defined in Dutch law. Remember, we said that we need to look at Article 3.2, but Dutch law doesn't say anything. Because now the court says, because the convention is based on the model of the OECD, the commentary to that model convention is important for the interpretation of this term. And I mean, just, by the way, the court throws in this rule of interpretation of treaties, again, without referencing the Vienna Convention. And I think the court is right in doing so, or at least if you read the commentary, it says you should look at the commentary if you want to understand what the terms in the treaty means. And the commentary is very clear. I mean, it's not referenced in the treaty or anything like that. But one could say that it is in the international common practice that tax authorities and taxpayers look at the commentary when they interpret the treaty, right? So I agree with the court here. And the court then goes on to say, and it appears from the commentary that the term income derived from the operation of immovable property is a broad concept and that it concerns any form of exploitation of immovable property. Now actually, the commentary on Article 6 is very short, and the commentary on paragraph 3 even shorter. It is more direct words of paragraph 3, which says here the provision of this part shall apply to income derived from the direct use or any other form, which is very wide, not the commentary, which is very wide. Nonetheless, the court is right in quoting, saying, viewed in this way too, there is no reason to assume that keeping the movable property available for oneself cannot be regarded as exploitation, nor does the context of that article preclude this interpretation. Therefore, the grounds of appeal fail, and then Mexican taxpayer loses the case and basically have to pay the tax. Now, there's 2 points here. One is, why has the Advocate General or the court not made more of the Spanish text? I mean, very clearly, the texts of the treaty are equally authentic, right? And very clearly, there's a difference between utilisación directa and the words rechtstreekse exploitatie, which should have been rechtstreeks gebruik. It seems like the court has skipped a method of interpretation here, which is a pity. It could have been an interesting point supporting the court's conclusion. And the second one is that the Advocate General did reference Klaus Vogel in his opinion, and Klaus Vogel also expands quite a bit on a number of pages on Article 6.3, and explains in there that there are a number of countries which tax the own use of real estate as an income, as deemed income. It doesn't say exactly how the countries do it, but he mentions at least 5 or 6 who does it, and says that this is allowed under Article 6.3. So they could have had some extra support there. There's one last case which throws an interesting twist on this one, and it's referred to as the Dutch Supreme Court Christmas case, or I would like to say Christmas gift, from 2021, because in that case the Dutch Supreme Court said, you know what, this deemed income under box 3 is built on a basis which is too high compared to the actual income realized by the taxpayer, and that is not allowed under the what is the European Treaty on Human Rights. The Protocol 1 to the treaty, Article 1, allows for the peaceful enjoyment of property, right? And you cannot peacefully enjoy your property if the state comes and tax more of it than you have. That there's something unfair about that. So the Advocate General does discuss this issue. He says, and the taxpayer has raised it as one of its objections against this tax. And it says, in view of the foregoing, the Supreme Court, now this is from the case from 2021, has ruled that also take into account the wide margin of appreciation that the legislator is entitled to. It cannot reasonably be said that it has been the fixed rate system applicable in 2017 can withstand the proportionality test. In other words, it goes further than needed, and the proportionality test arises from Article 1 of the first protocol, Eerste Protocol, of the Convention on Human Rights. So this case is interesting in that it also touched on human rights conventions and their influences that they can have on taxes, right? There is no relationship between the interest that the legislator intended to serve with the system and the inequality caused by the design chosen by the legislator to achieve that goal. Because, in other words, the legislator is taxing more than he should, and there's no reasonable relationship there. And then the Advocate General goes on to explain why. He says, in particular, the desire to promote feasibility or simplicity, I think is meant here, and increase tax revenues do not provide sufficient justification for the significant difference in treatment between those who reap positive benefits from the risky investments that they make and earn a higher return than what the Netherlands is taxing, and those who also enjoy tax privilege treatment, right? Because if you are a risky, successful investor, you've got more money and you can pay more tax, but you actually pay proportionately less, right? And the Advocate General says, if you compare those to those who have passed on that fortune because they invested conservatively in low returning assets, they have to pay more tax than what their income is, right? So those who are conservative and prudent and who have been the system is allocated a relatively heavy tax debt, right? So the system almost forces you to do risky investments just to be able to pay the tax on the deemed income that is arising. And if you don't, then you pay more tax than you have income. And the Supreme Court threw this box 3 income out for that reason in December 2021, and so it became the Supreme Court's Christmas gift. And it begs a number of questions, right? I mean, the Advocate General talks about this, and he says the case led to the Christmas judgment involving a taxpayer in view of the fact that the taxable income from savings and investments is calculated in the same way for non-residents as for residents. This judgment applies, in my opinion, to non-resident taxpayers. That's what the Advocate General means. This means that when assessing this dispute, the situation must now be assessed on the basis of the Christmas judgment. The above means that it must be investigated whether, and if so, to what extent the interested party, in other words the Mexican residents, is disadvantaged by the box 3 levy, and the Advocate General goes on to say that then they should only be taxed on the actual value or the actual worth of owning the apartment rather than this box 3 worth. The Supreme Court doesn't do anything with this, and the question is why, right? Why have they ignored? They don't even mention saying they disagreed with the Advocate General, and it opens the question about whether there are other treaty procedures which can now be pursued. And the first one that obviously comes to mind is the mutual agreement procedure, and here we see the English text under Article 24 of the Dutch-Mexican Treaty, and says, where a person considers that measures adopted by one or both contracting states shall result or may result for him in taxation not in accordance with the provisions of this convention. And the question here is whether this deemed box 3 income, which already has been thrown out for Dutch residents, should also be thrown out for foreign residents, because it is taxing more income potentially more income than the couple earned from using their own property, whether that is not in accordance with the provisions of this convention. And I would argue that it is not in accordance with the provisions of this convention, because obviously it is not the intention of the convention to condone one state to tax the residents of another state on income that the resident of the other state never have received. So it'll be interesting to see if the taxpayer will pursue MAP on this issue in this regard. Obviously, we may never know because MAP procedures are not published. And the second one is non-discrimination. And you know, because very clearly, I mean, for Dutch residents, this box 3 income does not apply. Would it then apply for foreigners? This is the classical text covered by Article 23, one would think, but it is not, because it says nationals of a contracting state shall not be taxed, subjected in any other contracting state to any tax or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which nationals of the other state in the same circumstances may be subjected. And the problem, I think, here is that these two people that moved from Holland to Mexico are not necessarily Mexican nationals. As a matter of fact, I think they are Dutch nationals. And part of the reason why I'm saying that is elsewhere in the facts describing the case, it is said that they kept the apartment to also be able to visit family when they are in the Netherlands. So at least Article 23(1) non-discrimination would not work here, but I think the taxpayer certainly has chance under the mutual agreement procedure to fight this decision. That's all I have for you for this week. I hope you found it as interesting a case as I did, bringing up as many different issues as it does about the meaning of income, the meaning of exploitation, differences in translations between treaties and which to follow, which sources one should look at when interpreting treaties, and finally a bit of discrimination and a bit of taxation not levied in accordance with the provisions of this convention. I look forward to seeing you again next week. Bye for now.